Well, my question really was not whether this website is a public accommodation. I understand that's been stipulated. That wasn't my question. What I'm trying to understand is the breadth of your argument. And what I get is that you're making a tiny sliver of an argument. So the website can put anything on its website, even something that will blatantly or subtly tell a same-sex couple, whoa, this is not a service that I want. They can do that. And the website can also potentially get itself out from being a public accommodation simply by reserving a degree of selectivity. That's what you've told me so far.
No, I don't think it's just by reserving a degree of selectivity, but I think the more selective and sort of curated the process is, it makes it less likely to be a public accommodation, as the court recognized in Fulton.
All right, let me ask you, and then I'll finish this line, some hypotheticals in a brief submitted by Josh Blackman. A Jewish man and a Jewish woman who were engaged to be married ask a Jewish website designer to build a website to celebrate their their nuptials. No problem, okay? Another Jewish man and a Christian woman who were engaged to be married ask a Jewish website designer to build a website to celebrate their nuptials. Big problem. Quote, many Jews consider intermarriage an existential threat to the future of Judaism. Does that website have to accept the second couple?
Again, as we talked about before, if the Jewish website designer has, very explicitly Jewish themes on the wedding, they don't need to, on the website, they don't need to take that down for the interreligious couple that comes. But if they offer a general service to the public, they need to offer that regardless of the customer's religion.
So the fact that they offer this that this is a Jewish, that is offered mostly to Jews, that's enough to make it, or exclusively to Jews, that's enough to make it sufficiently selective to get them out from your...
No, I'm drawing a distinction between what the website designer chooses to put on the website and who the website designer sells the website to. The website designer can choose to put on their websites whatever they want, but they just can't refuse to sell, if they're a public accommodation, they can't refuse to sell that website to someone solely because of their customers or the couple's religion.
Okay, an unmarried Jewish person asks a Jewish photographer to take a photograph for his J-Date dating profile. It's a dating service, I gather, for Jewish people.
It is.
All right, maybe Justice Kagan will also be familiar with the next website I'm going to mention. So next, a Jewish person asks a Jewish photographer to take a photograph for his ashleymadison.com dating profile. I'm not suggesting, I mean, she knows a lot of things. I'm not suggesting. Okay, does he have to do it?
Well, again, it would, what Colorado it depends. What Colorado looks to is what services the photographer makes available to the public. And if the photographer makes that service available to others taking pictures, for use on websites, then probably yes. But it depends on.
Okay, Justice, then I really will stop. Justice Jackson's example of the Santa in the mall who doesn't want his picture taken with black children. So if there's a black Santa at the other end of the mall and he doesn't want to have his picture taken with a child who's dressed up in a Ku Klux Klan outfit, that black Santa has to do that?
No, because Ku Klux Klan outfits are not protected characteristics under public accommodation laws.